First District Court of Appeals, 9th session. Although I have business before this court, draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case scheduled for oral argument this afternoon, the case of Florida Prepaid College Board versus Intuition College Savings Solutions, LLC. Counsel, ready to proceed? You may approach. Counsel, we have allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal, please.
So noted, Madam Clerk. You may continue, Counsel.
Thank you. May it please the Court, my name is Andy Bardos with the Gray Robinson Law Firm on behalf of the Florida Prepaid College Board. Your Honor, this Court should reverse the final order of the ALJ invalidating prepaid's dispute resolution rules for 3 reasons. First, Intuition lacks standing. Second, the legislature reviewed and authorized these very rules. And third, the rules are not an invalid exercise of delegated legislative authority. Intuition lacks standing because it accepted these very obligations separately in its contract. It agreed to them. It agreed to follow this dispute resolution process and therefore assumed an obligation that's entirely independent of the rules themselves. Invalidation of the rules, therefore, would not relieve Intuition of its obligation to follow the dispute resolution process and would afford Intuition no relief. The parties have had a lengthy relationship, 25 years, in which they've signed 3 contracts. Intuition has agreed to this dispute resolution process all 3 times. In the latest contract, which was publicly procured pursuant to an ITN after a lengthy procurement process, they accepted this for the 3rd time, and simply months after they signed the contract, they turned around and challenged this provision, and alleged for the first time that it was unfair, something that they could have negotiated around pursuant to the ITN in the procurement process. They could have sought a waiver and a variance, as Ernst & Young did. That letter is in the record as well. So they could have avoided taking on any sort of contractual obligation. By avoiding the contractual obligation, they could have attacked the validity of the administrative rule. But what they cannot do is assume a separate, independent obligation to follow these procedures and then attack the provision that's in the administrative rules.
What if the rule was amended such that it said the board always wins? In any dispute, the board's always right. Would they have no remedy at that point?
That's a very difficult question, Your Honor. I don't. Obviously, they would have a remedy in that case. This is not that case. I don't know exactly how to answer that.
Would there be a rule challenge possibly, or how would that? I'm curious.
Well, I guess it would depend on the language of the contract. If the contract says that they would be required to follow the rule as amended from time to time, then that would be an ongoing incorporation of the changes to the administrative rules. Something quite that stark, Your Honor, I don't know. Certainly, if the rules are amended to change the process, and they've agreed to that by contract, they could potentially raise an argument that that it gives prepaid a right unilaterally to amend the contract, and there are limitations that case law recognizes on that, on the ability of one party pursuant to a provision in the contract that allows the law to be amended from time to time for that one party to amend it unilaterally. So there is a reasonableness limitation on that.
But it sounds like no matter how arbitrary or capricious the rule change might be, your argument would be they still have to abide by it, pretty much.
I do think, Your Honor, that there is case law saying that if there is a change to the law that's being incorporated into the contract, and it amounts to a unilateral amendment of the contract, there are limitations on that, and there is a reasonableness limitation on that. So I think that that's obviously not an issue that the parties briefed, and not case law that the parties have presented in their briefs, but I think the court would find that there is a limitation on the extent to which a party can unilaterally, by changing the law that's being incorporated into the contract, change the contract.
Are there any other entities that the board is contracted with that would be subject to these rules in a dispute resolution context? Or is this the one and only entity?
That's not in the record, Your Honor. The prepaid has contracts besides this one. It has a contract with Ernst & Young. Ernst & Young obtained a waiver from these very provisions during the procurement process, which is something that Intuition clearly could have done here. It's certainly not something that is limited to Intuition in any way. This is a provision that could be incorporated into contracts with other vendors, in which other vendors could attempt to either waive or simply exclude from the contract during the negotiation process.
Counsel, in view of the parties' contract, could we determine whether Appley is contractually bound by the board's dispute resolution process, independent of the validity of the rules?
I'm sorry, Your Honor. Could you repeat the question?
Can we, this panel, determine whether Appley is contractually bound by the board's dispute resolution process, independent of the validity of the challenge rules?
I think yes, Your Honor. I think the ETS case demonstrates that parties are free to contract and enter into dispute resolution provisions, even where one party is a state agency. I'd also add that it was Intuition's burden to prove its standing, and so if this record is insufficient to demonstrate that the contractual provision is unenforceable, then Intuition bears the burden of that, and then Intuition has failed to establish its standing. So it wasn't our burden to establish that Intuition lacks standing. So if there's anything, and Intuition argues in its briefs that this provision might be unenforceable, it doesn't really explain why. It never raised that below. If for any reason it's unenforceable and they can't point to something in the record, that's their failure to meet that burden. So it was their burden to establish that in the record, to establish their standing. Otherwise, I think the court has to assume that pursuant to the EDS case, which we've cited, this provision would be enforceable as a matter of contract.
Assume that they have standing. Can I jump you ahead to your ratification, grandfathered, saved, whatever you want to call it, argument? What was the specific statutory language that ratified this?
The specific statutory language is now found in Section 1009.9714Y, and that language says the prepaid has authority to, quote, adopt procedures to govern contract dispute proceedings between the board and its vendors. And that language was tailor-made to validate these rules, because these were among the 2,000 or so rules that were referred to the legislature. The legislature, therefore, had actual knowledge of these rules. It knew that these rules existed. It knew that that prepaid was seeking authority to enforce these rules. And in light of that, they adopted this precise language that talks about procedures to govern contract dispute proceedings. And so I think the only logical inference from that, especially when we look at the 1996 legislation, in which the legislature said that it would be considering legislation to authorize rules that are being referred to it after the APA standards had been increased, the only logical conclusion from that is that the legislature had reviewed these rules and sought to authorize them. Otherwise, it would not have adopted language like this, and by operation of the 1996 statute, those rules would have been repealed.
So this doesn't specify the procedure. So basically, any procedure that the board adopts is good and immune from any kind of challenge?
I think we can say for sure that the procedures that the legislature was aware of and had actual knowledge of are immune from challenge because the legislature authorized those. If their legislature had found some fault in those rules, it would not have authorized this language. It reviewed them and it said, we're keeping these rules. We want these rules to stay in effect, and that's why we're adopting this language. Now, if prepaid were to modify those rules and then rely on this, then I don't know that it would have the same argument that those rules were specifically authorized by the legislature. They might come within the legislature's grant subsequently, but it would be similar to any other rule situation where the grant of authority comes first and then the rule is adopted afterwards. But here, because the rule was adopted first and then the legislature, in light of that rule, which had specifically been referred to it, authorized those rules, I don't see how we can then say, well, the rules that the legislature had before it and which it enacted legislation to authorize are somehow unauthorized or not authorized because it's an invalid exercise of delegated legislative authority.
But counsel, wouldn't the board's ratification argument apply to all agency rules for which the legislature provided statutory authority as part of its APA revision process in the late 1990s?
I think it would. I think, well, it would depend on the language of the statute, but I think, Your Honor, it would. I think if the legislature had rules referred to it and specific rules going before it pursuant to an elaborate review and authorization process, the process that the legislature established for this very purpose of authorizing rules, and the rule is referred to it, and the legislature reviews those rules, and it enacts legislation to authorize those rules, I don't see how we can afterwards say that those rules are not authorized. I mean, otherwise, what else was the legislature trying to accomplish? What did the legislature do when it enacted 48 rule authorization bills in 1998? Clearly, it was trying to do something, and what it was trying to do was validate these rules, which is what it said it was doing in the 1996 legislation. Otherwise, we're not giving those 48 rule authorization bills any effect.
I thought I read somewhere, though, that the rules couldn't be challenged for a certain time period, then they presumably could be.
Right.
What's the necessity for that?
And so that was just a 2-year moratorium while rules were being referred to the legislature, and the legislature was considering authorizing those. And so the legislature said, okay, for these 2 years, we're going to put a freeze on rule challenges to these rules so that we, the legislature, have time to review those rules and then to confer the authority that we want to confer on them, or not. And if we don't confer authority on them, then those rules by operation of law will be repealed. So it was to preserve the status quo, to give the legislature time to review those rules and authorize them. And then but then once the legislature came in and authorized them, the moratorium expired because the legislature had had a chance to act. Then the authorization took effect. And clearly the authorization has to have some meaning. It has to have effect. And we haven't seen from intuition any explanation of what that could have meant other than that the legislature wanted these rules to be in effect and validated them according to the new APA standards.
Counsel, does application of the rules require the board to contract with DOA for an ALJ pursuant to section 120.65(6) Florida statutes, or could the board refer the matter directly to DOA without having such a contract?
So it is, what the rules contemplate is a contracted ALJ process. Because, first of all, contract disputes are not cannot be adjudicated by DOA under the APA. The case law is clear that the APA does not confer jurisdiction on DOA to determine breach of contract claims. So we could not have created that sort of jurisdiction under the APA for DOA. So what we had to do was create a process in which we utilize an ALJ, but it's not under the jurisdiction of the APA. It's under the separate 120.65 subsection 6 authorization to utilize ALJs to resolve non-APA proceedings. And so it clearly contemplates that. And what demonstrates that further is the fact that there are provisions in our rules that modify those 120.57 hearings. Obviously, we wouldn't have authority to modify 120.57 if this were a true APA proceeding, but it's not. The legislature gave the prepaid authority to modify the procedures however it wanted, and it borrowed procedures from 120.57, utilizing contracted ALJ services, and it could have done any number of other things to establish this procedure. But that's clearly what the rules contemplate in our view. That's how we would apply it to utilize a contracted ALJ. When the contract is entered into is a matter of discretion. The procedure hasn't been utilized in 25 years, so it could be referred to DOA, and then there could be a contract between prepaid and DOA. So the fact that there hasn't been a contract yet is simply a reflection on the fact that the procedure has never been utilized before.
What is your rebuttal time, counsel? However, review the questions. We will extend your rebuttal time by an additional 2 minutes. We will extend counsel Apley's argument time by an additional 2 minutes as well.
Thank you, Your Honor.
You may proceed, counsel.
Thank you. Good afternoon. I'm Steve Menton with the law firm of Rutledge Assini on behalf of the Applee Intuition College Savings Solutions. I want to address the standing and ratification issues that Mr. Bardos spent some time on just a few minutes ago. But before I do that, I think it's important to step back and keep in mind the nature of the case that's before you today. This is not a contract case. It's not a contract interpretation case. It's an appeal from a rule challenge proceeding brought pursuant to Section 120.56 that resulted in the ALJ concluding that the rules at issue were invalid because they created a one-sided, unfair process that was vague and improperly modified the established procedures for hearings conducted at DOA pursuant to Section 120.57 Florida statutes. In our brief on pages 5 and 6, 19, 32, 33, and 36 through 40, we quoted from some of the specific findings that the ALJ made based upon the evidence presented to her at the proceeding below. The following paragraphs are particularly important. In paragraph 10, the ALJ explained that there was no requirement for the board to timely disclose the basis for its decisions. In paragraph 11, she found that the rules did not require the board to explain the basis for its withholding of payment, nor did the rules provide a mechanism for a vendor such as Intuition to obtain the information necessary to formulate a petition challenging the decision. In paragraph 13, she concludes that the rules are vague in terms of what must be included in the petition. And then later, in paragraph 39, she concluded that the rules created an irrational, impossible, one-sided stacked deck against a vendor seeking to challenge an adverse decision or action.
Counsel, under the challenge rules, doesn't the ALJ perform an appellate function and view the correctness of the board's determination?
I'm sorry, Your Honor.
Under the challenge rules, doesn't the ALJ perform an appellate function in reviewing the the board's rules?
Your Honor, I don't think that's correct. I think what the rules say is that the matter is referred to DOA for a Section 12057 proceeding. A 12057 proceeding is a very established process. It's not an appellate process like they tried to argue in their brief. So that assertion on their part is incorrect. 12057-1K, which is not addressed in their briefs, I would suggest you need to take a look at that. It says specifically that any proceeding conducted under 120.57 is a de novo proceeding. It's not an appellate proceeding. It's a de novo proceeding. And so the board here specifically in its rules referenced 120.57. It did not reference 120.56 subsection 5 that Judge Bilbrey referenced in some of his questioning, which is the contract provision where DOA can contract with outside agencies. There was no contract here. The board's rules do not reference a contract. There is nothing that supports the contention that that's how the process is to be conducted. The only provision in the rules states 12057, and 12057-1K specifically says it's a de novo proceeding. And the judge, in great detail, laid out how the board's rules improperly modify the established procedures for hearings at DOA. So the board spends a lot of time relying upon the EDS case. Well, the EDS case incorporated a 12057 process without modification. The EDS case was not a rule challenge case. It was simply a question of whether you can contract to have alternative dispute processes. We don't dispute that. But that's not the issue that's before you. The issue that's before you is whether the rules that were adopted are specifically consistent with the requirements of a fair process and whether or not they comply with the requirements of 12057-1. And the judge found specifically that they did not. And there's no basis in the record to overturn her factual findings as to the one-sided nature of the process that's been established here.
Counsel, this may be a dumb question, and maybe I'm just confused, but I'm looking at the dispute resolution paragraph. And paragraph B of paragraph 33 is talking about what we're here today about, the sole and exclusive manner of resolution of claims is pursuant to the rules. Fine. But then the next paragraph, this is where I'm totally confused. It says, if any litigation arises under this contract and after the exhaustion of administrative remedies, any and all such litigation shall be instituted in the circuit court. So this is a weird-looking animal to me because it sounds like, on one hand, paragraph B is saying, hey, go talk to the board, try to resolve it through the dispute process, no matter how unfair it might be in your view. And if that doesn't work itself out through that process, and if there's any litigation, you go to circuit court. So are you envisioning going to circuit court at some point?
Your Honor, I think that's what my client would like to have the right to do, but I think the testimony at the hearing was very clear from the board's representative that from the board's perspective, they viewed the process in their rules as the exclusive method. So they
But then why paragraph C? I don't understand. Why is there a paragraph C that says if any litigation under this contract arises, you go to circuit court? It doesn't say go to the board. It says go to circuit court.
And, Your Honor, though, when we asked the board's representative in deposition and at the hearing whether we could go to circuit court, the testimony was that if we went to circuit court, they would come in and claim we did not exhaust our administrative remedies.
So that's my point. It sounds, if I'm looking at this, I'd say, well, it sounds to me like you have to go through this administrative process with the board. You may not like it, it may not be as protective of your rights as you might think, and once that's over, if you still have a dispute or a beef about it, then you can litigate, but you have to kind of give it a try with the board first, no?
Your Honor, I don't believe that that's the process that the board contemplates.
Okay.
And in discussions we had with the board about our ability to do that, the indication is that if we go through that process, the resolution from DOA was going to be binding on us. And there was no option. There is no, clear path for us to get to circuit court.
Is there a rule that says the board's decision is binding, that you can't go to circuit court?
It says it's the only place that we can go is to go to
But
DOA.
then that nullifies C. You get what I'm getting. I don't see how it can be the sole and exclusive manner when C says no, well, you can still go to circuit court.
Well, and that's part of the conundrum that we were in, Your Honor, is because in the discussions that we had with the board over these contract issues, they made it clear that any attempt by us to go to circuit court, they were going to invoke, that provision in their rules and say that we haven't exhausted our administrative remedies.
But wouldn't you just wait for a live controversy to arise and put them to the test on that? Try to work it out within the board, and if it doesn't work out, you go to circuit court, and then we'll find out what C means.
Well, but Judge, I think that if we go to circuit court after we go through this process, they're going to come back and say that that's an order from the DOA judge that the circuit court judge is not going to overturn. And we've never had an opportunity to conduct discovery or even to find out the basis for the decision upon which the board made. So we're hamstrung to have to go to an administrative process, administrative 12057 hearing, without the ability to even require the board to fully disclose the basis for its decision, and then we're stuck with the result of that administrative process. And there is nothing in there that gives us the ability to appeal to circuit court or appeal to this court. I think the problem we would find ourselves in is that if we go to circuit court, they're going to say, well, this is like an arbitration provision. You went to arbitration, you lost, there's no appeal from that arbitration provision. It's an alternative dispute process that they incorporated, they forced us to go through. Then they're going to claim it's binding on us without the ability to go to circuit court and vindicate the rights that we have or even to conduct a discovery related to the basis for the decision against us.
On the timeliness, one of the issues that you mentioned that the ALJ found was the lack of some sort of timeliness requirement by the board to make a decision. Wouldn't mandamus be the remedy there if you file a complaint with the board and they sit on it for 2 years? At some point, you bring mandamus, I would guess to us, maybe to the circuit court, and somebody orders them to move it along?
Well, that's a possibility in the case of just a delay, but I think the ALJ's findings went even beyond that we weren't even entitled to, there wasn't a mechanism for us to even obtain the information upon which the decision was based. There was no way for us to force the board to turn over to us the basis upon which the decision was made. So it's not just a timeliness issue, it's also a disclosure issue, and I think the judge found the rules deficient on both of those grounds.
Well, if what the ALJ is doing is an appellate process, then the fact that the board, has an opportunity to explain to that judge the basis for their decision, isn't that where you would find out why they reached the decision?
Yes, but the way that the rules are set up, and as the ALJ specifically found, at that point in the proceeding, we have no ability to amend our petition or even to present any additional evidence to rebut whatever the board brings forward. And so that's why the process is so unfair. It's skewed and it's one-sided, where only the board has the right to present additional evidence to the ALJ once the matter gets referred to DOA. We go to DOA, we don't have the ability to present any new evidence that wasn't already there, irrespective of what the board might come forward with in front of the administrative law judge. And that's exactly why the administrative law judge found the process to be so troublesome, is it's so one-sided and it's so stacked against the vendor.
But in that case, counsel, wouldn't the board filings be a response to your petition?
Yes, but the issue, Judge, I think, is that they can respond, but they can also bring forth new evidence to respond to the issues that we raise. And if they bring forth new issues in response to what we raise, we have no ability to respond to that. We don't even know going into the hearing process what that's going to be. We're going to be at DOA in front of an administrative law judge. They're going to be able to come up with new justifications for whatever contract decisions that they may have made. We don't have any opportunity to learn that in advance. We don't have any opportunity to conduct discovery as to the validity of that. And we don't even have the ability to present evidence to contradict what they may present at that point. It's just they have written the rules such that we cannot come forward with any new evidence after the matter is referred to DOA. And that's inconsistent with the Section 12057 process, which they have specifically incorporated. They've modified numerous provisions in the Uniform Rules of Procedure which govern all Section 12057 proceedings. They haven't referenced the 12056-5 contract provisions. There is no contract for us to understand how that process is supposed to work. And so it's a kangaroo court. And the administrative law judge specifically found that it's not incorrect to call this a situation where the board is acting as judge, jury, and executioner all in one fell swoop. And that's why these rules were deemed to be invalid.
There's been no disputes in 25 years of contracting?
Pardon me?
There's been no disputes in 25 years?
25, well,
of
I think
relationship?
everybody looks at those provisions, and quite frankly, Judge, that's the situation with my client. Now, in terms of the contractual provisions, that were referenced, we did proffer at the hearing below evidence as to the negotiations related to those provisions, how they came about. And the judge, I think correctly, we proffered that evidence in the abundance of caution because the board was raising all these standing issues. And so we said, well, wait, Judge, here's evidence that we believe will go to whether or not these contractual provisions are enforceable, whether there was waiver or estoppel or fraud in the inducement or even constitutionality. We attempted to bring those forward in the administrative proceeding below. And the judge specifically said, I don't have jurisdiction to resolve those issues. And I think she's right. I think she was correct in that. We proffered that evidence just to make sure that when we got before you, we could say, well, we tried to bring forth these contractual issues. The judge did not rule on them. She did not accept the evidence. It's not before you today to resolve what the contractual rights of the parties are. That's for another day. The only issue that the judge addressed and the only issue before you today is, are these rules an invalid exercise of delegated authority? She made specific factual findings explaining why they are, and I think those factual findings are supported by competent substantial evidence, and you should affirm.
So if we did affirm, what happens next?
I think if the rules are invalid, I think the board in its brief states, and they have told us, that they're going to take the position that we're still bound by the contractual provisions and we have to follow the invalidated rules. I'm not sure how that's going to play out. I mean, we'll have to see. But again, that's not an issue before you today. But
Well, no, but I'm trying to think down the road. I mean, I'm trying to understand the end game here, because it sounds like you all probably have a dispute, need to get it resolved, and we've got a lot of different ways to litigate it. Rule challenge, circuit court maybe, but it seems like if there's been a 25-year relationship and very little dispute, it seems like it's something that can be worked out.
Well, we tried. I can assure you that, Judge.
What's the nature of the dispute? I know it's $700,000. Is it they've withheld $700,000, but they haven't told you why? Is that what you?
That's the basis of it. There were several different issues that were involved, and in multiple instances. And again, I'm not sure that this is completely in the record. What's in the record and what the party stipulated to is that they withheld $700,000 or over $700,000 from invoice submitted, and that there was testimony at the hearing from our representative that he didn't understand why, and he tried to get information why and couldn't get it, so he didn't have the basis upon which to file a petition to even start this process. So the specifics of the $700,000 are not really detailed, but the
What's the
existence.
term of the contract? How many years? It's 2019 is when the contract began?
I think it's a
The current one?
5-year contract. I'm not sure, Your Honor.
Okay.
I'd have to go back and look.
All right, so you have time to work it out.
Now, with respect to the ratification issue, I just quickly want to address that before I sit down. I really hate to date myself here, but looking around the room, I'm probably the only person here that was actively practicing administrative law on a full-time basis back in 1996. So I was there when those provisions were initially adopted. The 1996 rewrite of the APA was a very significant change in administrative law in the state of Florida. It was an attempt by the legislature to rein in what it believed to be agency rulemaking that was being done without legislative authority. And one of the significant additions to the APA in 1996 was the provision that every rule had to have specific legislative authority. That did not exist prior to 1996. So the legislature in 1996 added a new requirement. As part of that, they included a new basis for challenging rules based upon the lack of a specific legislative grant of rulemaking authority. So what they did to remedy or to address the fact that there were thousands of rules that had been adopted without that provision being in place is they created this process for agencies to come forth and admit the rules didn't have a specific legislative authority, and then they could try to get that authority. It wasn't a substantive review of the merits of any of the rules. It was simply a way to come into compliance with the new requirements of the 1996 amendments. So in terms of, I think there was a question asked earlier about whether or not see my time's running out, but the ratification issue, I think, has been blown way out of proportion in terms of what happened, and you put it in a historical context. The window of opportunity that was created was to keep those rules from being challenged on the new grounds that there would lack specific legislative authority, and there was a presumptive period that was granted for 2 years that you were in compliance until that time period ran up. That time period went away, but there was never an attempt to inoculate rules from any kind of challenge at all.
Thank you, counsel.
I'd like to begin on the merits of the issue of invalid exercise of delegated legislative authority. We have to remember here that we're here on a facial challenge, so the only question before the court is there a lawful way to apply these rules, or will they be unlawful in every context and every circumstance? And also the rules must be construed in a way to preserve their validity. So when Mr. Menton talks about a kangaroo court, and he's talking about interpretations of these rules that would destroy their validity, those are not interpretations that this court on an appeal from a rule challenge should be adopting, because these rules are certainly capable of being interpreted in a lawful way. For example, Mr. Menton is concerned that prepaid will apply the rules in a way that allows them to spring new evidence on intuition at the DOA proceeding. That's not how we interpret the rules at all. Subsection 5 of Rule 14.003 says that no information is permitted after the case is referred to DOA. That applies to both parties. In fact, we interpret the rule to require the factual record that we produce to be part of the written determination that the executive director renders, because that determination is referred to in the rules as prepaid's response. We provide with that our responsive record. So is there a way to lawfully apply these rules and validly apply these rules? Of course there is. Judge Bilber, you had asked about about the time limitation on a determination. There is a time limitation on prepaid's ultimate determination, which is the one that ultimately triggers the proceeding at DOA. That's 45 days from the time that the petition is filed. Prepaid is required to render that decision within that period of time. What is not time limited is the initial notice that goes to intuition to say, here we have a dispute, here's our issue, and you now have 21 days to challenge it. But the issuance of that notice, does nothing other than start their clock to file their petition. They could file a petition today. They could have filed the petition back in November of 2019 when this issue first arose. So the only thing that notice accomplishes is it puts them on the clock within 21 days to file their petition. As long as we don't issue the notice, they can file their petition at any time. So the fact that there's no deadline on serving that notice simply benefits them. It doesn't benefit us.
If I could ask you the same question about interpreting paragraph 33.
Yes.
I mean, it seems to me that there's an administrative remedy. That's to go to the board. It has to be exhausted, and if that doesn't work out the parties' concerns, off to circuit court. Where am I wrong?
I was just about to turn to that, Your Honor. Okay. So we do read the rules to establish the exclusive procedure, as Mr. Menton said, for the resolution of claims that vendors bring against prepaid. So that procedure contemplates proceedings before prepaid, an appeal or review by DOA, and then an appeal pursuant to 120.68.
Does the rule say that?
The rule says sole procedure, and so it outlines the procedure, and we believe that the end result of that is final agency action, which then triggers rights under 120.68. Where that paragraph 33C comes in is these rules govern only disputes brought by the vendor against prepaid. The contract is broader than that. It's talking about all disputes that could occur between the two parties. So there could be situations in which prepaid, for example, has administrative remedies against Intuition, such as this case, where it has a remedy under its contract to withhold $700,000 if it believes that Intuition is not performing its services. And so if prepaid pursues those remedies first, and then still doesn't get relief, then it can go to circuit court. So there are circumstances in which there can be disputes between the parties that end up in circuit court, but the rule governs the disputes between parties that arise from the vendor, claims brought by the vendor against prepaid. And in those situations, like we talked about, our reading of the rule is it goes to DOA and then it goes to the DCA pursuant to 120.68. So that's the effect that paragraph 33C does have, where this proceeding here, which is the sole procedure, is not invoked. For example, if prepaid is the one bringing the claim against the vendor, that's where 33C might apply. But we don't believe that circuit court is an option or a backstop to the procedure that's outlined in these rules. And I see my time has expired. We would ask the court to reverse the ALJ's final order. Thank you.
Thank you, counsel, for your respectful oral arguments this afternoon. This concludes our oral arguments for this afternoon, and we stand adjourned.
All rise.